in the matter of George against Cannell and another.
Lord Legate will hand down this judgment.
This appeal raises questions about what compensation can be recovered in a claim for malicious falsehood. Malicious falsehood is a civil wrong which is committed when someone maliciously publishes words, false words, that cause another person financial loss. The claimant, Fiona George, was employed by a recruitment agency, LCA Jobs Limited, which I will refer to as LCA. LCA was owned and operated by a Ms. Linda Cannell. Fiona George resigned from LCA and was then employed by another recruitment agency. She soon began targeting clients of LCA, her former employer. Linda Cannell, her former boss, told 2 third parties, one of whom was Fiona George's new line manager and the other a client of LCA, that by doing this, Ms. George was in breach of her contract of employment with LCA. In fact, as Linda Cannell knew, there was no term in that contract which prevented Ms. George from soliciting business from LCA's clients after she left LCA's employment. Fiona George sued Linda Cannell and LCA for damages for malicious falsehood. The trial judge found that the statements made by Linda Cannell to the 2 third parties were false and malicious because Ms. Cannell did not believe them to be true, which in law is sufficient to prove malice. But the judge also found that the statements had not caused Fiona George any financial loss, because she showed a copy of her contract with LCA to her new line manager, who saw that it contained no relevant restriction on contacting LCA's clients, and because the client of LCA whom she had approached had already decided not to do business with her new employer anyway. The judge held that in the absence of any financial loss, the claim could not succeed, and he therefore dismissed the claim. The Court of Appeal reversed this decision. They held that although Fiona George could not recover damages for financial loss because she had not suffered any, she could recover damages for injury to her feelings caused by the publication of false and malicious statements to the 2 third parties. The defendants, Linda Cannell and LCA, have appealed to the Supreme Court. By a majority of 3 to 2, the Supreme Court allows the appeal. I, Lord Legate, give the majority judgment with which Lord Hodge and Lord Richards agree. Lord Hamblin and Lord Burrows give a separate judgment, agreeing in part, but dissenting in the result. 2 main issues are raised by the appeal. The first is an issue about the effect of a statutory provision, Section 3(1) of the Defamation Act, 1952. This provision was intended to make it easier to succeed in an action for malicious falsehood. It says that in such an action, quote, "It shall not be necessary to allege or prove special damage if the words upon which the action is founded are calculated to cause pecuniary damage to the claimant, and if they're published in writing or are calculated to cause pecuniary damage to the claimant in any office, profession, calling, trade or business." This last requirement was satisfied here. The term special damage in this context is a term of art which essentially means demonstrable financial damage. The background to Section 3(1) is that under the common law, proof of pecuniary damage, i.e. financial damage or loss, is an essential element of a claim for malicious falsehood, so that unless it is proved that the publication of the words has caused demonstrable financial loss to the claimant, no wrong has been committed. So Section 3(1) is saying that it shall not be necessary to prove that you have suffered financial loss in order to succeed if the words published are calculated to cause such loss. The defendants argued that where Section 3(1) applies, it creates a presumption that financial loss is likely to have resulted from the publication of the false words, even if there's no evidence of such loss, but that this presumption can be rebutted, so that if the evidence shows that no financial loss actually occurred, the defendant will not be liable. The Supreme Court is unanimous in rejecting that argument. In our view, on the correct interpretation of Section 3.1, whether the words published are calculated to cause pecuniary damage, i.e. financial loss, is to be judged at the time of publication by asking whether, given the facts which the defendant knew or should have known when publishing the words, their publication was likely to cause the claimant financial loss. If this condition is fulfilled, it is irrebuttably presumed that at least some financial loss was caused. There's no presumption, however, as regards the amount of such loss. Sometimes it's possible to infer from the circumstances that the claimant is likely to have sustained a significant amount of financial loss, in which case the court will estimate the amount and award damages for it. But if the evidence shows that no loss was in fact suffered, the claimant will only be entitled to nominal damages, that is to say, a token sum of money. Here, the false statements made by Linda Cannell to the third parties were, on the facts known to her, likely to cause Fiona George financial loss, even though, as it turned out, none was actually suffered. Liability was therefore established, although no financial loss occurred which the defendants must be ordered to compensate. Because liability has been established, the second issue arises. This is whether Fiona George, although she suffered no financial loss, can recover damages for injury to her feelings caused by the publication of the false and malicious statements. Two members of this court, Lord Hamblin and Lord Burrows, in agreement with the Court of Appeal, consider that the claimant can recover damages for injury to her feelings, and that this follows from the conclusion that liability can be established, and has been established here, without proof of any financial loss. Their reasoning is developed in their dissenting judgment. The majority of the court disagrees and has reached a different conclusion for reasons that I will briefly summarise. Malicious falsehood is described as an economic tort because it protects purely economic interests. I've mentioned that under the common law, financial damage is an essential element of the wrong. The wrong consists in the infliction of financial loss by maliciously publishing false words. Where the infliction of such financial loss results in injury to the claimant's feelings, for example, because the publication of a malicious falsehood badly damages the claimant's business, causing him acute distress and anxiety about his livelihood and his family's future, the damages awarded can include compensation for these injured feelings, as well as for the financial loss inflicted. That is because the injury to feelings is a consequence of the infliction of financial loss. That the claimant cannot recover damages for hurt and indignation and other injured feelings caused simply by learning that the defendant has published false and malicious words about her, because psychological or emotional well-being is not an interest protected by the law of malicious falsehood. Causing injury to feelings by maliciously publishing false words is not a legal wrong. In our view, Section 3.1 of the Defamation Act 1952 has not altered this. Where Section 3.1 applies, it gives rise to an irrebuttable presumption of financial loss, but it was not intended to transform an economic tort into a psychological one, and does not have this effect. Thus, Section 3.1 does not enable a claimant to recover compensation for injury to feelings where the injury to feelings is not a consequence of any financial loss, because none has been suffered. There is a separate principle that applies in relation to any wrongdoing, that if the defendant's conduct in committing the wrong or in responding to the claim was especially insulting, so-called aggravated damages may be awarded. But there was no such conduct which could justify awarding aggravated damages here. The upshot is that the claimant, Fiona George, cannot say that her feelings have been injured as a result of financial loss caused by the publication of false and malicious words, because the judge specifically found that she suffered no financial loss as a result of the publication. She is therefore entitled only to nominal damages, which we have fixed in the sum of £5.
The court will now adjourn.